Hello, I will be talking about laws and ethics in forensic investigations. Assignment two that will contain two parts, part A and B, and this will be the part A1. So I will be talking about analyzing a fictional but uh, all too realistic cybersecurity ethics case called the Quiet Breach. This scenario presents us with a fundamental question that every security professional may face at some point. So, what do we do when your organization wants to hide a data breach from the people whose data was stolen? So, the case involves someone named Jordan Wells as chief security officer at a major rideshare company who discovers a significant data breach and faces enormous pressure from leadership to conceal it. Over the next uh, presentations, I will examine this situation and through multiple heads, multiple different aspects like ethical frameworks, legal requirements, professional standards, and technical controls. So let's get started with the scene. A major US rideshare company, like think companies like Uber or Lyft, discovers that hackers have accessed an obsolete backup environment and copied millions of rider records. I'm talking about phone numbers, email addresses, partial payment information, and driver identification data, quite sensitive. Here is where it gets ethically complex. The attackers sent a polite, business-like message asking for a bug bounty payment in exchange for deleting the data. The executives see an opportunity here. Instead of disclosing the breach as required by law, they consider classifying this ransom payment as a legitimate security engagement. No one needs to know the difference, someone suggests. Jordan Wells, our CSO, now faces a critical decision. Does she follow executive pressure and participate in the concealment, or does she fulfill her professional and legal duty to ensure affected users are notified? This is the central ethical dilemma I will be analyzing today. So let's analyze the situation through two major ethical frameworks: deontological ethics and utilitarian ethics. Deontological ethics from Kant. The Immanuel Kant's categorical imperative gives us three key tests. First, the duty to truth. Kant argued we have an absolute duty not to deceive. Concealing a breach while users continue trusting the company with their data is a clear violation of this duty. Users have a fundamental right to know their data was compromised. Second, the universalizability test. Ask yourself, what if all companies concealed breaches? The entire trust framework of digital commerce would collapse. So you couldn't trust any company with your data because you would never know if they've been breached. The third, respect for persons. Kant's principle that we must treat people as ends in themselves, not merely as means. Here, users are being treated as means to protect corporate reputation, not as autonomous individuals with rights to make informed decisions about their own data security. The utilitarian ethics from Bentham and Mill asks us to maximize overall well-beings. At first glance, concealment might seem utilitarian, avoiding stock drops, lawsuits, and reputational damage, but true utilitarian calculus must consider all affected parties. Millions of users could become victims of identity theft and fraud if not notified. The long-term harm to these individuals and to society's trust in digital services far outweighs the short-term corporate financial concerns. When you run the full calculus, disclosure clearly produces greater overall good. The virtue ethics from the Aristotle focuses on characters. It asks, what kind of person do you want to be? What kind of professional does Jordan want to be? Three virtues are particularly relevant here. Honestly, a virtuous person does not deceive stakeholders, even when disclosure is painful. Courage. Jordan faces intense pressure to comply with executive wishes. Courage means standing for what's right despite personal consequences, potential job loss, career damage, professional isolation. Integrity cover ups moral character over time. Once you participate in one deception, it becomes easier to participate in the next. You become the kind of person who covers things up. The social contract theory from John Rawls' veil of ignorance through experiment is very powerful here. Behind the veil, you don't know if you will be an executive, a security professional, or one of the millions of affected users. What policy would rational agents choose? The answer is clear: mandatory disclosure. Anyone could be a victim. We all implicitly agree to share our data with companies, expecting reasonable protection and a notification if that protection fails. Concealment violates the foundational social contract between companies and users. Now let's examine the legal landscape. This scenario takes place in the United States, so we need to consider both federal and the state laws. So the federal laws, the FTC Act Section 5 prohibits unfair or deceptive acts. Claiming your data is secure while concealing a breach is textbook deception. The FTC can impose fines up to $50,000 per violation per day. And with millions of users affected, those numbers add up very fast. The Gramm-Leach-Bliley Act may apply if the payment data qualifies as financial information. The safeguards rule requires notification with penalties up to $100,000 per violation. Officers can face personal fines up to $10,000 and even imprisonment. The Computer Fraud and Abuse Act creates interesting complications around the ransom payment. Paying attackers may implicate CFFA provisions if funds reach criminal enterprises. You cannot legitimize extortion by calling it a bug bounty. The state laws. All 50 states now have breach notification laws. California's CCPA requires notification within 30 days with fines of $2,500 to $7,500 per violation. New York's SHIELD Act requires reasonable security. For a national rideshare company operating in multiple states, the exposure multiplies dramatically. So the prosecution likelihood, this is important. The prosecution likelihood is very high. The FTC actively pursues breach concealments. Remember that the Uber's 2018 case that resulted in 148 million settlement. State attorneys general collaborate on multi-state actions. Prior settlements, as mentioned in our scenario, actually increases scrutiny, and executives face personal liability and potential criminal charges for obstruction. Beyond regulatory penalties, let's consider the full spectrum of the consequences. The legal exposure, the class action lawsuits. Plaintiffs can claim negligence, breach of contract, and violation of consumer protection statutes. Evidence of cover-up dramatically increases damages through punitive awards. Juries don't like companies that hide things from customers. Securities violations. If the company is publicly traded, failure to disclosure material cybersecurity incidents violates SEC disclosure requirements. Executives face personal liability under Sarbanes-Oxley. This isn't just about the company, it's about individual accountability. Government sanctions. The OFAC sanctions may apply if ransom payments reach sanctioned entities. Companies can be debarred from government contracts. Operating licenses may be revoked. Reputational impact. The trust destruction. Users who learn of concealment rarely return. The brand damage can be permanent. Investors' flight. The ESG conscious investors increasingly divest from companies with governance failures. Talent exodus. Ethical employees leave when they discover cover ups, and recruiting top security talent becomes nearly impossible. Media scrutiny. Cover ups generate sustained negative coverage that eclipses the original incident. The cover up becomes the story, not the breach itself. Jordan Wells presumably holds professional certifications. Let's examine what those codes of ethics require. Professional codes. The IS-2 Code of Ethics, which governs CISSP holders, has four canons. Canon 1. Protect society, the common good, necessary public trust and confidence. Canon 2. Act honorably, honestly, justly, responsibly, and legally. Canon 3. Provide diligent and competent service. Concealment violates all three of these canons. ISACA's Code of Ethics for CISA and CISM holders requires supporting the public interest, maintaining the integrity, and following professional standards. The ACM Code of Ethics explicitly states that computing professionals shall be honest and trustworthy and avoid harm. So the broader impacts will be on the profession. Cover-ups erode public trust in all security professionals, invite stricter government regulations, damage the credibility of certifications, and create precedent for a cover-up culture through the industry. On society, victims cannot protect themselves from identity theft when they don't know their data was stolen. Fraud continues undetected. Corporate deception becomes normalized. Democratic accountability is undermined when companies operate without transparency. Now let's examine what went wrong technically. The scenario gives us several clues about security devices. So the apparent devices, the legacy system exposure, the obsolete backup environment remained accessible. This suggests either shadow IT or decommissioning failure. Systems that should have been removed or secured were left exposed. Inadequate data segmentation. Millions of records were accessible from a single entry point. Proper network segmentation should prevent this kind of wholesale data access. Weak access controls. The backup containing sensitive data apparently lacked multi-factor authentication, encryption at rest, or proper access logging. Delayed detection. While the breach was eventually detected by monitoring, the data had already been exfiltrated. Detection came too late to prevent the harm. So the specific remediations like asset inventory, implement continuous asset discovery and decommission or secure all legacy systems within 90 days. Zero trust architecture, implement micro-segmentation and require authentication for all east-west traffic. Encryption and DLP, encrypt all data at rest using AES 256 and deploy data loss prevention to detect and block bulk exfiltration. SIM and SOAR enhance detection with behavioral analytics and automate response to reduce dwell time below 24 hours. Technical controls alone don't prevent ethical failures, so let's discuss about the organizational factors as well. Tone at the top leadership. This is critical. The CEO's willingness to conceal the breach reflects organizational values. Ethical leadership must be modeled from the top. Boards must hold executives accountable for governance failure, not just financial performance. When leadership signals that concealment is acceptable, it poisons the entire organizational culture. Organizational culture. Organizations must create psychological safety for reporting bad news. They should reward transparency, not just outcomes. Ethics must be integrated into performance reviews. Whistleblowers' protection must be real, not just policy statement. Governance structures. Consider these structural changes. Board level cybersecurity committees with real authority. CISO reporting directly to the CEO, not buried under the CIO. Independent ethics officers with the power to escalate concerns. Regular third party security audits. The newspaper test. Every organization should apply this simple test. Would this decision survive front page scrutiny? If you would be embarrassed to see your decision reported in the news, it's probably the wrong decision. Let's talk through the prioritized frameworks for technical controls. High priority controls. Comprehensive asset inventory. You can't protect what you don't know you have. Multi-factor authentication everywhere. Encryption at rest for all sensitive data. Network segmentation to contain breaches, endpoint detection and response on all systems. So the medium priority controls will be the CM with user and entity behavior analytics, data loss prevention tools, privileged access management, regular penetration testing, threat intelligence feeds. And ongoing programs can be the vulnerable management programs, security awareness training, backup testing and validation, third party risk assessments, compliance monitoring. So the defense in depth, the key insight here is that no single control prevents all breaches. Effective security requires layered defenses where each control provides backup if another fails. The obsolete backup environment in our scenario should have been protected by multiple overlapping controls. Access management, access control, encryption, monitoring, decommissioning procedures. Any one of these working properly might have prevented this breach. So what should Jordan do? The answer after the analysis should be clear. The three mandates. Ethical mandate. Every major ethical framework, deontological, utilitarian, virtue ethics and social contract theory points to disclosure as the morally correct path. There is no ethical justification for concealment. Legal imperative. The federal and the state laws require notification. Concealment exposes the company to criminal prosecution, massive civil liability, and regulatory sanction. The legal path is unambiguous. The professional duty as a CSO, Jordan's professional codes demand she protect society and act with integrity. Her personal reputation and certification are at stake. Professional ethics leave no room for participating in cover-ups. The bottom line disclose the short-term pain of transparency is always preferable to the long-term destruction of concealment. Every breach that has been covered up and later discovered has resulted in far greater damage than if it had been disclosed immediately. So as you can see, the cover-ups is always worse than the crime. So this is basically a lesson for every breach. Eventually ends up with concealment ends up with worse. So these are my references. This is part A2. In this case, I will examine the fascinating and increasingly relevant case in AI ethics, learning to see. This scenario takes place in London at a company called Artifacts Model Limited, which has developed a groundbreaking generative image engine. So the core question this case forces us to confront is profound. When an AI system learns from millions of human created images, is it learning in an educational sense, or is it taking in a way that violates the rights of creators? This is just an abstract philosophical question. It has real legal, professional and economic consequences that I'm gonna try to explore throughout this. So let's set the scene first. Uh, Artifacts models has become the darling of London's tech scene. Their generative image engine can create portraits, landscapes, and imaginary worlds so vivid that galleries have started displaying AI-generated art alongside human works. They have investors pressing for global launch within the quarter. The pressure is intense. But then engineers discover something troubling while combing through the training dataset. Fragments of newspaper photographs, fashion campaigns, imagery, even a royal portrait. The web scraping pipeline had absorbed millions of copyrighted and personal identifiable images without any consent mechanism or licensing. The board's initial response is dismissive. Everyone is using open data, no one owns pixels. But this dismissal ignores the legal reality and the ethical implications. When an artist recognizes her distinctive watermark reproduced in generated image and the journalists start asking questions about an expose, the situation becomes untenable. Dr. Owen Rao, the head of research who nurtured this model for years, now faces central dilemma. Does innovation justify what the scenario calls silent borrowing from countless creators? So let's analyze this through our ethical framework, starting with deontological and utilitarian perspectives. Deontological ethics, the Kant's categorical imperative is particularly illuminating here. First, consider property rights. Using creators' work without permission treats them merely as means to artifacts' ends, violating their autonomy and rights as creative individuals. Artists didn't consent to have their life's work become training data for a commercial product. The universalizability test is devastating. If all AI companies scraped copyrighted works without consent, the creative industries would collapse. Why would anyone invest years developing an artistic style if it can simply be absorbed into an AI model that competes directly with them? The duty to the truth is also violated. Launching the product while concealing known IP violations is fundamentally deceptive to users, investors, and society as well. The board's suggestion to proceed without disclosure is a form of institutional lying. Utilitarian ethics from Bentham and Mills. A shadow utilitarian analysis might favor innovation. New technology benefits consumers and advances AI capabilities. But true utilitarian calculus must consider all affected parties. Millions of creators whose work was taken without consent face real economic harm. The long term effect of undermining creative livelihood and eroding trust in the AI technology must be weighed against the short term innovation benefits. The virtue effects. From Aristotle's perspective, this is fundamentally about character. What kind of person does Dr. Rowe want to be? What kind of company does Artifacts want to become? Honestly, requires acknowledging that building commercial success on others' uncompensated labor is ethically problematic, regardless of technical legality. Justice demands fair dealings. Creators deserve recognition and compensation for their work. The fact that technology makes it easy to take their work doesn't make it right. Courage is what Dr. Rao needs now, standing against board pressure and competitive urgency to prioritize ethics over immediate profit. Distributive justice. The Rawls theory of justice is particularly relevant. The difference principle asks who benefits and who bears the burden. In this case, AI profits flow predominantly to tech companies and investors, while artists, often economically precarious, bear the creative burden without compensation. Behind Rawls' veil of ignorance, not knowing whether you would be a tech executive or a struggling artist, rational agents would demand consent mechanism and fair compensation. The current system lacks procedural justice entirely. Creators have no open opportunity to consent or opt out before their work is absorbed. Now let's examine the United Kingdom legal landscape. Uh, this is crucial because Artifacts is a London-based company and subject to UK laws. So first would be the copyright law. The Copyright Design and Patents Act in 1988 is the primary UK copyright statute. Mass scraping and reproduction of copyrighted works for AI training likely constitute infringement. Critically, there is no explicit fair dealing exception for commercial AI training under UK law, unlike some interpretations of US fair use doctrine. The UK Intellectual Property Office has been consulting on this issue, but as of now, the legal position remains that copyright holders must be respected. Data protection. The UK GDPR and Data Protection Act 2018 create additional exposure. Personal images require a lawful basis for processing. Scraping identifiable photographs, including those royal portraits and fashion companies' images mentioned in the scenario, without consent violates data protection law. The Information Commissioner's Office can impose fines up to 17.5 million sterling or pound or 4% of global annual turnover, whichever is higher. Other laws, database rights under the 1998 regulations may also apply if the artifacts extracted content from protected databases like newspaper archives, and if their scraping bypasses access control or violates term of service. The Computer Misuse Act in 1990 could create criminal liability. The Getty Images lawsuit against Stability AI, filed in the UK Higher Court in 2023, demonstrate that these aren't theoretical concerns. Courts are actively hearing AI training data disputes. Beyond regulatory penalties, artifacts face a cascade potential consequences like legal exposures. Copyright infringement claims could come from individual artists or collective licensing bodies like DEX, Design and Artist Copyright Society, or ACS. Under the CDPA, remedies include statutory damages, accounts of profits, and injunctive relief, potentially requiring artifacts to retrain their model from scratch with clean data. GDPR enforcement is another vector. ICO investigations for unlawful personal data processing could result in enforcement notices requiring deletion of training data containing identified images. Directors may face personal liability under the Companies Act 2006 if they fail to exercise reasonable care regarding known legal risks. So the reputational damage will be the consequences may be worse than the legal ones. The creative community is vocal and organized. An artist boycott and public backlash could poison the brand before it launches. The journalist mentioned in the scenario is already investigating. Negative coverage will dominate the launch narrative. Galleries may refuse to showcase AI art amid controversy. ESG conscious investors increasingly avoid IP controversies. Funding rounds could collapse. The company's reputation may never recover at all. Dr. Rao and engineering team likely hold professional membership with ethical obligations, so the professional codes. The BCS Code of Conduct requires members to have due regard for public health, privacy, security, and well-being, and to act with integrity. Launching a product with known IP violations clearly breaches these standards. The ACM Code of Ethics is explicit. Principle 1.5 states members should respect the work required to produce new ideas, inventions, creative works, and Principle 1.6 requires respective privacy. Mass scraping of creative works without consent violates both. IEEE's Code of Commit engineers to be honest and realistic and avoid injuries, others, their properties, reputation, or employment. AI model trained on others work without compensation directly injure creators' livelihood. So the broader impacts extends beyond artifacts. On the profession, cases like this erode public trust in AI development, invite restrictive regulation like EU AI Act, and create a move fast and break things culture that devalues ethical practitioners. On society, this threatens creative economy livelihoods, concentrates value extraction in tech companies, undermines the very concept of artistic ownership, and may chill future creative productions as artists fear their work will simply be absorbed. Now let's examine the technical failures that enables this situation and the apparent deficiencies, uncontrolled web scraping. The pipeline ingested copyrighted content with no filtering for right status, licensing, or personal data indicators. This is a fundamental data governance failure. No data provenance tracking. This scenario notes that filtering would take months, perhaps years. This indicates no provenance metadata exists. They cannot determine the source, license, or consent status for training images. Inadequate personal identifiable information detection. Identifiable faces, watermarks, and signatures are embedded in training data with no face detection or PII scrubbing implemented. Modern memorization. The fact that an artist's watermark was reproduced in generated output suggests overfitting. The model may be capable of regurgitating copyrighted content verbatim. The specific remediations data lineage systems using tools like MLflow or DVC can track sources, URLs, licenses, and consent status. The copyright filter pipelines using perceptual hashing, watermark detection, and the reverse image search can identify and exclude protected content. PII detection using phase detection models and OCR can identify and blur or exclude personal data. Output guardrails can compare generated images against training data to block outputs that are too similar to specific copyrighted works. So how could this have been prevented? Let's start with the governance and the culture. Tone at the top. The board's dismissive response, everyone does it, no one owns pixels, signals ethical apathy from leadership. This tone cascades through the organization. When leadership trivializes IP rights, engineers receive the message that compliance is optional. Ethical leadership would instead model respect for intellectual property and data organizations as core values, not obstacles to innovation. Organizational culture. Prevention requires empowering engineers to raise data concerns without career risk. It requires mandatory ethics review before product milestones, not after problems emerge. It means rewarding progressive innovations, not just speed to market. Governance structures. Effective governance includes an AI ethics committee with real veto power, legal review of training data sources before collection begins, independent data provenance audits, and clear escalation paths when concerns arise. Stakeholder engagement is also critical. Proactive dialogue with artist communities, collective societies, and rights holders before, not after model development. The technical controls should operate at every stage of the AI development life cycle. The pre-training controls, the most important controls happen before training, using only licensed data from sources like Shutterstock or Adobe Stock, implementing provenance tracking from the moment of data ingestion, deploying automated copyright filtering, and building consent verification into data collection pipelines. During the training, techniques like differential privacy can reduce memorization risk. Regular testing for memorization style transfer limitations and comprehensive audit logging create accountability. Post-training and after training, similarity matching guardrails can detect when outputs too closely resembling training data. Watermark detection in outputs, consent provenance metadata following C2PA standards, and robust opt-out takedown mechanism round out controls. The industry best practices, importantly, ethical AI development is commercial viable. Adobe Firefly uses only licensed and public domain content. Shutterstock pays contributors when their work is used for AI training. These approaches demonstrate that responsible AI development is possible. It's a choice, not a technical limitation. So, what should Dr. Rao do? The scenario ends him pausing backstage, hearing the countdown, wondering whether progress demands brilliance or coincidence. My answer, it demands both. The three imperatives. The ethical imperative. Every moral framework we examined, deontological, utilitarian virtue ethics, and justice theory, recognizes that building on others' creative work without consent or compensation is wrong. The ethical path is clear. Legal reality. The UK law provides no safe harbor for AI training on copyrighted works. The CDPA, UK GDPR, and emerging case law create significant litigation risk. The Getty Images lawsuit shows courts will act. So the professional duty, BCS, ACM, and IEEE codes are all require respect for intellectual property and privacy. Dr. Rao's professional standing and the AI field's reputation hang in the balance. The right path is the recommendation is clear. Delay, remediate, rebuild. Delay the launch until the data provenance issue is resolved. Remediate by filtering copyrighted and personal content or retraining on properly licensed data. Rebuild the model on an ethical foundation. Yes, this is harder. Yes, competitors may move faster, but the true innovation creates value. It doesn't merely extract it from others. The companies that will thrive long term are those building AI responsibly with the creative community as partners rather than unwitting suppliers. Dr. Rao should stop countdown. The exhibition hall will still be there when they have a product they can be proud of, one that demonstrates the progress and consciousness can coexist. And these are my references. Now in part B, I will be diving into one of the most contentious topic in cybersecurity ethics, the concept of hacking back, a digital retaliation against cyber attackers. This isn't just a theoretical exercise, it's a question that security professionals face with increasing urgency as attacks grow more sophisticated and damaging. The subtitle will capture our core inquiry: when does defense become an offense? At what point does a victim of cyber attack becomes an aggressor? These questions will matter because they define not just what security teams are permitted to do, but who they are as ethical actors in an increasingly contested digital space. So let's start with setting the context. Modern cybersecurity really does resemble a battlefield, but one without clear front lines, defined combatants, or agreed upon rules of engagement. When organizations face persistent intrusions, months of data exfiltration or destructive attacks on critical systems, the frustration breeds a powerful urge to fight back. But here is a fundamental problem. In cyberspace, the line between defense and offense blurs dangerously. The same tools used to monitor an attacker can be used to access their systems. The same skills that protects networks can be turned to penetrating them. This creates what we might call the defender's dilemma. Security professionals face intense pressure from multiple directions. Borders demands visible protective action. Silence looks weak. Clients expect robust response. Restraint seems irresponsible. Sometimes governments encourage actions, the other times they restrain it. The public judges both inaction and overreach harshly. Navigating these expectations while maintaining legal and ethical boundaries is enormously challenging. We need to be precise about terminology because the language shapes how we think about these issues. The Department of Defense defines active defense as the synchronized real time capability to discover, detect, analyze, and mitigate threats and vulnerabilities. So, this sounds purely defensive, but the implementation can be anything. So, I've laid out a spectrum here for clearly legal to clearly illegal on the green end. We have traditional passive defenses like firewalls, intrusion detections, threat intelligence, patch management. So no one disputes these are legitimate. In the yellow gray zone, we have beaconing, embedding tracking code in documents that alerts you when the stolen files are opened, sinkholing, redirecting malicious traffic to controlled servers, deception technology, fake credentials, and honeycombs. And these are increasingly common but raise questions. In the orange, legally risky zone, counter intrusion, accessing attacker command and control servers, attempting to retrieve stolen data. These actions, even with good intentions, likely violate computer crime laws. And in the red, full of offensive hackbacks, destructive attacks, data destruction, system sabotage. This is unambiguously illegal for private actors in virtually every jurisdiction, yet surveys suggest it happens more than publicly acknowledged. So let me walk through these specific techniques in more detail because understanding what's technically possible help us reason about what's ethically permissible. Beaconing embeds tracking code in documents. When stolen files are opened, they phone home, revealing the attacker's location. Honeypots are decoy systems designed to attract attackers, waste their time, and gather intelligence. Deception technology creates fake credentials and false network topology to mislead intruders. Moving into gray areas, sinkholing redirects malicious traffic to controlled servers, disrupting botnet infrastructure. This often requires ISP cooperation and may affect legitimate traffic. Counter-intrusion means accessing attacker system to gather intelligence or identify perpetrators. Network interdiction blocks attacker infrastructure at network level. At the far end, offensive hackback deliberately attacks adversary systems. Rescue operations attempt to delete stolen data from attacker servers. These cross clearly legal lines regardless of the motivation. Uh, Jay Kaysen and Carol Hayes, in their seminal 2012 article called The Spectrum Mitigative Counter-Striking, a useful framework for thinking about graduated responses. So why is it so hard to draw clean lines in cyberspace? The ambiguity is both technical and conceptual. Technically, the same reconnaissance tools work for both defense and offense. Nmap scans your network or theirs. The code doesn't know the difference. The speed of execution compresses moral reasoning. Automated defenses must respond faster than human deliberation permits. And packets cross jurisdictions invisibly. Your defensive action in one country may be an attack under another's laws. Conceptually, we struggle with whether cyberspace is more like property or territory. If it's a property, self help has historical precedent. If it's territory, the state claims monopoly on force. Modern doctrine like persistent engagement and defending forward deliberately blurs these lines. And attribution uncertainty means we often don't know who attacked us with confidence. Thomas Reed and Ben Buchanan captured this beautifully. In cyberspace, the distinction between offense and defense is less a bright line than a matter of degree, direction, or intent. So let's look at how states have actually used cyber retaliation because this shapes the environment in which private actors operate. Stuxnet in 2010 was the first acknowledged cyber weapon. The US and Israel used it to destroy Iranian nuclear centrifuges. It was a tactical success, setting back Iran's program by perhaps 2 years, but it escaped containment, spreading globally and demonstrating that cyber weapons have unpredictable blast radius. It also set a precedent that states would conduct offensive operations in peacetime. After North Korea attacked Sony Pictures in 2014, the US responded with sanctions and reportedly briefly took down North Korean internet. This was the first public acknowledgement of proportional cyber response to a private sector attack. But did it deter? North Korea went on conduct WannaCry in 2017. The 2016 DNC hack by Russian intelligence triggered intense debate about appropriate response. The Obama administration limited public response to sanctions and diplomatic expulsions, criticized by many as insufficient deterrence. Russian cyber operations continued through 2024. Private sector actions operate in different legal space but face similar dilemmas. Microsoft's Digital Crime Unit has pioneered using civil court orders to seize botnet command and control domains. They have disrupted TrickBot, Emotet, Nicors, and others. This is legal. They went through courts but represents private institutions assuming functions traditionally reserved for law enforcement. CrowdStrike's role in attributing the DNC hack to Russian raised questions about private sector influence on national security matters. Their analysis was accepted and drove policy, but what accountability exists for private attribution claims? Most significantly, industry surveys suggest substantial unreported private retaliation. A 2017 survey found 36% of companies had engaged in some form of hackback, though definitions varied widely. Most remain secret due to legal risks, creation what criminologists call a dark figure we can't measure. The key lesson from both state and private cases, retaliation has shown a limited deterrent effect. Attackers continue operations regardless. Neither has solved the fundamental problems of attribution and proportionality. Attribution is the Achilles heel of any retaliation strategy. As Reed and Buchanan put it, attribution in cyberspace is always probabilistic, never certain. The attacker chooses whether to leave evidence, and sophisticated actors rarely do. The technical obstacles are substantial. Attackers route through proxy chains of compromised third-party systems. The attacker you see may be another victim. Sophisticated actors plant false flags, deliberately mimicking the techniques of other groups. And shared infrastructure like cloud servers, VPN, CDNs host millions of users simultaneously. We need to distinguish three layers of attribution. Technical attribution asks which machines were used. This is the easiest but least meaningful since the machines can be hijacked. Human attribution asks which individual operated the keyboards. This requires intelligence beyond network data. State attribution asks which government directed or permitted the attack. This is hardest because plausibly deniability is designed in here. The ethical implication is profound. If attribution is uncertain, retaliation risks punishing innocence. Just war tradition requires reasonable certainty before using force. Cyber operations rarely meet this standard. Beyond attribution error, there is the problem of collateral damage. This isn't theoretical, we have documented examples. NotPetya in 2017 was a Russian attack targeting Ukraine, but it escaped spreading globally. Maersk lost $300 million. Maersk lost $870 million. FedEx lost $400 million. Total global damage exceeded $10 billion. The attack completely escaped its target zone, affecting companies with no connection to the conflict. WannaCry also in 2007 was North Korean ransomware that hit the United Kingdom National Health Service. 80 plus NHS organizations were affected. Surgeries were cancelled, patients' care was disrupted. Healthcare wasn't targeted, it was just collateral damage from wormable malware. Even Stuxnet, designed for an air-gapped Iranian facility, escaped to the global internet, infecting systems in Indonesia, India, and elsewhere. So, why does containment fail? Shared hosting means attacking the IP affects all its users. Wormable exploits self-propagate without respecting targets. Supply chain attacks cascade. SolarWinds showed how one compromise affects thousands. Critical infrastructure shares network with civilian systems. The moral conclusion here, unlike kinetic weapons, cyber weapons cannot be precisely targeted. Any retaliation carries inherent risk of harming innocents, violating principles of discrimination and proportionality that are central to just war ethics. The just war tradition developed over centuries to govern armed conflict provides ethical criteria we can apply to cyber operations. Maria Rosaria Taddeo and Rondel Dippert have done excellent work in this area. Jus ad bellum, the right to respond, includes requirements like just cause, legitimate authority, right intention, and last resort. In cyber context, was the attack serious enough? Who may authorize response? Can private companies ever legitimately strike back? Is the goal to stop harm or to punish? Have we exhausted peaceful options like law enforcement? Just in bello, right to conduct during conflict includes discrimination, proportionality, necessity, and reasonable chance of success. Can we distinguish combatants from civilians in cyberspace with shared infrastructure? Is destroying systems proportionate to data theft? Is this action necessary or could less harmful means work? Will retaliation actually achieve its goal or just escalate? Tadeo's conclusion is sobering. Cyber operations rarely satisfy just war criteria. Attribution uncertainty undermines just cause. Shared infrastructures violate discrimination. Unpredictably spread violently proportionally. The framework that has governed military ethics for centuries struggles to accommodate cyber reality. Just war theory isn't our only ethical lens. Let's see how other framework analyzes hackback. Deontological ethics, Kant's categorical imperative, asked whether hackback could be universalized. If everyone retaliated, the internet becomes a war zone. This fails the universalizability test, risking harm to innocents on shared infrastructure treats them as means, not ends. And competing duties create tension. Do defenders have a duty to protect that overrides the duty not to harm? Utilitarian ethics weigh outcomes. If hackback deters future attacks, net utility could be positive, but evidence of deterrence is weak. Expected harm to innocent must be weighed. Given cybersecurity unpredictability, expected harm is high. And escalation may reduce net utility for everyone. Virtue ethics can asks what a person of good character would do. Aristotle distinguished courage from recklessness. Through courage is reasoned response, reckless retaliation is vice. Practical wisdom, phronesis, requires understanding consequences. Uncertain attribution means prudence counsels restraint. Social contract theory notes that the social contract grants states exclusive rights to violence. Private hackback usurps this function. Behind Rowe's veil of ignorance, not knowing whether you would be a tech company or a misattributed innocent, would we permit private retaliation? Ethics aside, the legal landscape is clear. Private hackback is illegal almost everywhere. In the United States, the Computer Fraud and Abuse Act 18 U.S.C. 1030 prohibits unauthorized access to computer systems, period. There is no self-help exception. Accessing attacker's system, regardless of your victim status, is a federal crime. Penalties can reach 10 years per violation with aggravated penalties for national security systems or causing damage. The Active Cyber Defense Certainly Act, proposed in 2017 and 19, would have created limited safe harbor for beaconing, sinkholing, and data retrieval. It never passed. Even those proposals excluded the destructive attacks. Internationally, the Budapest Convention on Cybercrime, with 68 plus parties, criminalized unauthorized access regardless of motives. The vigilante exception exists. The Tallinn Manual, while not binding, represents expert consensus that international law constrains cyber operations. Private actors receive no special permission. The bottom line, under current law, private hackback is illegal in virtual every jurisdiction. The gap between what companies want to do and what they legally can do remains vast. Organizations contemplating hackback face several liability exposure. Criminal liability is real. CFFA violations can result in federal prosecutions with up to 10 years per count. Corporate criminal liability extends to directing officers. Planning hackback with vendors creates conspiracy liability even before execution. And actions crossing borders create exposure in multiple jurisdictions. Risk of prosecution abroad, even Interpol red notices. Civil liability may be even more dangerous financially. Innocent parties on shared infrastructure can sue for damages, tortious interference, negligence, trespass to chattels. If collateral damage affects many parties, class action exposure is significant. NotPetya scale incident would generate massive liability. Shareholders can bring derivative suits against directors who authorized illegal activity, alleging breach of fiduciary duty. Regulatory consequences include FTC and SEC scrutiny, loss of government contracts, potential debarment from federal work, and industry licensing revocations. Insurance won't help, cyber policies exclude illegal acts, and D&O coverage is voided for criminal conduct. This is critical and often overlooked. I was just following orders is not a defense. Security professionals who execute hackback operations face personal criminal prosecutions regardless of employer direction. CISOs and security directors authorizing hackback face personal liability. They cannot hide behind corporate structure. Incident responders with hands-on keyboard face direct prosecutions. Third-party contractors performing hackback for clients are equally liable. Contractual indemnification doesn't protect against criminal charges. Personal consequences are severe. Criminal penalties under CFAA can reach 10 years per count. Professional destruction follows. Security clearance revocation, certification loss, CISSP and CISSM have ethical requirements, and industry blacklisting. International exposure means travel restrictions and extradition risk for action crossing borders. All major professional codes prohibit this. The ISC Code of Ethics requires members to act honorably, honestly, justly, responsibly, and legally. ISACA require compliance with laws. ACM prohibits unauthorized access. Hackback violates every major professional standard in our field. Proponents of hackback often argue deterrence. If attackers face consequences, they will stop. Well, let's examine both sides. Argument for hackback. Attackers currently face no consequences. 95% of cybercrimes go unprosecuted. Adding cost may reduce attacks. Law enforcement lacks resources. Private action fills the enforcement void. Stolen data has time value. Waiting for authorities may mean data is sold before recovery is possible. Counter-intrusion gathers evidence law enforcement needs. So the argument against the hackback is the retaliation invites counter-retaliation. The Sony DPRK cycle showed tit-for-tat escalation. Attribution error rates, perhaps 20% plus for sophisticated attacks, means no one in 5 retaliation hit the wrong target. Innocents are harmed while real attackers go undeterred. Privatizing enforcement undermines a rule of law. Companies lack accountability, due process, or oversight. And the sophistication gap matters. Nation-state attackers have resources to counter-retaliate devastatingly. Companies may be picking fights they can't win. The Herbert Lin's analysis is compelling. The cyber deterrence has failed even at the state level. Stuxnet delayed but didn't stop Iran. Sanctions on Russia didn't prevent continued operations. Deterrence theory developed for nuclear standoffs may simply not apply to asymmetric cyber conflict. If states can't deter, why would private actors succeed? The question isn't hack back or do nothing. It's hack back versus the many legal alternatives. Let's walk through what's available. Enhanced passive defense. Zero trust architecture, microsegmentation, advanced EDR, deception grids make penetration so costly that attackers move elsewhere. This is investment in prevention rather than retaliation. Threat intelligence sharing through ISAC, CISA partnership, and vendor coalition multiplies capabilities without legal risk. Collective defense is more effective than individual vigilantism. Law enforcement coordination, like FBI, IC3, Secret Service, international partnerships, lets you provide attribution while authorities conduct countermeasures with legal authority. Civil litigation works when attribution is strong. Microsoft's botnet takedowns use civil courts, not vigilantism. Sue the attackers you can identify. Legal active measures include internal honeypots, deception technology, beacons within your own infrastructure, and syncalling with ISP cooperation. Insurance transfers financial risk without legal exposure. Diplomatic channels work for state-sponsored attacks, slow but legal. Public attribution campaign impose reputational cost. So the key point here is the framing retaliation as the only option ignores the defensive toolkits we have. So let's return to the question posed in our scenario. What kind of ethical actor is a defender allowed to be in cyberspace? We have choices about our self-conception. The Guardian protects assets within legal bounds, accepts that some attacks cannot be prevented, and measures success by resilience rather than retaliation. The Vigilante takes law into own hands, operates outside legal framework, justifies action through necessity and victim status. But risks become what they fight. The combatant embraces the warfare metaphor, sees cyber conflicts as continuous battle, but combatant status brings rules and private actors have none. These aren't just abstract categories, they shape real decisions. When you are in the heat of an incident, what you bring about your role determines what actions feel permissible. So the question for reflection will be, if we retaliate and harm innocents, are we different from our attackers? Does frustration with law enforcement justify abandoning the rule of law? What precedent do we set for others who might retaliate against us? Can we maintain moral high ground while acting outside the law? Luciano Floridi reminds us in the Infosphere, we are not just actors but constructors of our ethical environment. How we respond shapes what cyberspace becomes for everyone. So let's bring this together with the four key conclusions. Legal reality, hackback is illegal under CFAA, Budapest Convention, and most national laws. No safe harbor exists, personal and organization liability is severe and real. The ethical challenge, just war criteria are rarely satisfied. Attribution uncertainly means innocents are harmed. Collateral damage is inherent, not exceptional. Escalation likely exceeds any deterrent benefits. Practical wisdom is the legal alternative exists and work. Enhanced defense, threat sharing, law enforcement coordination, civil litigation, insurance. The choice is not hackback or nothing. Identity choice. Security professionals must decide who they want to be, guardian or vigilante, rule of law or self help. The answer defines not just what we do, but what we are as professions. My final message would be the restraint is not weakness. The true strength lies in building systems attackers cannot breach, not in becoming what we oppose. The Nietzsche's quote captures it. Whoever fights monsters should see to it that in the process he does not become a monster. And these are my references from academic sources to policy and government sources, and additional academic and legal sources to professional and legal standards.